Okay, I think we can get started there, just while the last few people trickle in. So my name is Charlie, and I'm an open source intelligence analyst here at Tech Against Terrorism, and delighted to welcome you all to the report launch of Designating Terrorism, the need for clarity and transparency to moderate online terrorist content. This is a landmark report that is coming out very, very shortly, as in today. And today we're going to go over some of what the report's about, and we've got some excellent speakers to deliver some really fantastic presentations on some of the kind of nuances and difficulties in the designation of terrorism on a global scale. Next slide, please. So just before we get started, just a couple of little housekeeping rules. This event is public, it's going to be fully recorded, and we will be posting it on YouTube afterwards. So please do feel free to share on social media. We're using the hashtag Designating Terrorism to promote the topic as a whole. So if you're discussing this online, please feel free to use the hashtag to get some momentum going around the discussion. We'll be having a Q&A at the end of the webinar. The Q&A function should be available already. So please feel free to put any questions into the Q&A throughout the presentations, and we'll try to get to as many as we can at the end. Next slide, please. So in terms of structure, I'll just give a brief overview. I'm the moderator for today, so I'll be passing between the speakers. And we've got Adam Hadley, the Executive Director and founder of Tech Against Terrorism, up first with some introductory remarks. Then we've got our 4 speakers who I'll introduce a little bit more in detail as we get to each one, and then our Q&A at the end. So without further ado, I will pass over to Adam for our opening remarks before getting on to the main topic of the report. Over to you, Adam.
Thank you very much, Charlie, and also a big thanks to Honor, who has written much of this report and carried out the research, and of course to Sarkeb, who's helped with the publication of the report that accompanies this launch. So I'm Adam, the Executive Director at Tech Against Terrorism, and delighted to be providing opening remarks for this launch of the designation report. Tech Against Terrorism itself was launched in April 2017 with the support of the United Nations Counterterrorism Executive Directorate. And we ourselves are grounded in a number of UN Security Council resolutions, and we recognise as best practice public-private partnership. For example, in Resolution 2354, Resolution 2395, and also the Security Council Note S 2007-375. The point that really we're trying to make here is that the genesis of Tech Against Terrorism is focused on the rule of law and supporting democratic governments in how they consider it best to deal with criminal activity, including, of course, terrorist activity online. And we believe it's essential that counterterrorism is grounded in the rule of law and democratic principles, for without focusing on democracy and the consensus that is part of democracy, if we somehow deal with terrorists in ways that don't support democratic norms, in many ways we believe that's undermining what we're trying to do. Terrorists, of course, intend to disrupt society and undermine society. And therefore, we believe that human rights and the protection of fundamental freedoms is essential in any mechanism and activity designed to counter terrorist use of the internet. Tech Against Terrorism focuses on practical disruption activities. We focus on tackling the terrorist use of the internet, and we do so in a number of ways. Firstly, we work to reach out to smaller platforms who are most vulnerable to terrorist use of their systems. We then aim to build capacity through knowledge sharing efforts, through mentorship. And we also build technology and technical approaches to support smaller platforms in handling this. Certainly one of the biggest problems small platforms have is because of limited capability and capacity, can potentially be a tendency to remove content that actually doesn't violate the law and isn't necessarily terrorist content. Where technology is concerned and technical approaches, we've built a system and a tool called the Terrorist Content Analytics Platform, and its website is terrorismanalytics.org. And everything we do with the TCAP, so essentially we work to identify terrorist content and then alert this to platforms for consideration. Everything we do with this is grounded on designation of terrorist groups. And that covers the extreme far right and also violent Islamist extremist terrorist organizations. But through this work, we recognized pretty early on that there were a number of significant problems with how designation was being applied. The principle of the TCAP was we wanted to ensure that we weren't making up norms, that we weren't somehow blurring the lines. So we deliberately focus on content that is clearly associated with designated terrorist organizations. And we believe in this regard that it's crucial to focus on the most obvious content first, content that is clearly affiliated, for example, with IS and Al-Qaeda, before focusing on other forms of content that is potentially more contentious. However, there are limits to this approach, considering the fact that there are a whole variety of approaches that are used by governments to recognize the legality or criminality of content relating to terrorist organizations. So we primarily set out in doing this research to improve our own policy background to the activity that we do at Tech Against Terrorism. And we wanted to understand in greater detail what is the normative basis of relying on designation processes in democratic countries. And we found that there were a number of significant problems with what was in place. So that's really the reason that we've done this research. Actually, it's primarily for our internal purposes and to ensure that everything we're doing with the TCAP is grounded in the rule of law, supporting the rule of law, and encouraging democratic governments to step up. We fundamentally believe that democracies are there to make difficult decisions in terms of guiding society and setting norms. Fundamentally, we do not believe it is the role of technology companies to establish international law norms, and we do not believe that it is up to tech companies to adjudicate on criminality. I should say that we've conducted also a huge amount of research looking at online regulation, and I commend viewers to look at the online regulation series and the material that we've produced that goes through, in a similar way to the designation report, emerging regulation across the world. And this is primarily designed to simplify what is an incredibly complex policy area so that platforms of all sizes can improve their understanding of their obligations under law. The terrorist content analytics platform has a phenomenally successful removal rate of over 94%. And much of this is because we're clear about connecting content we find to designated terrorist organizations. And certainly, anecdotally, we find that if platforms are aware of a legal basis for a removal request, they're significantly more likely to act on it. However, we also recognize that non-democratic countries subvert the rule of law and subvert human rights, and they pretend to use legal processes in order to apply pressure to tech companies. So we recognize the concerns there. And a large part of us writing this report and doing the research is to provide more guidance on this and also to spark conversation. We believe that governments can and should be doing more to clarify what is illegal and what is not illegal, because it's incredibly confusing. So certainly extremely grateful for the team at Tech Against Terrorism for doing this research, and also for the speakers today. I'm sure it will be an incredibly elucidating and illuminating conversation. So thank you once again.
Thank you, Adam. That was a brilliant introduction to the topic and obviously to Tech Against Terrorism as a whole. And now we'll hand over to Anna Khan, who is the research manager here at Tech Against Terrorism and is really the founder and has been the lead on the designation project since its inception. There's been an awful lot of very hard work that's gone into this, navigating some incredibly complex legislation, and I'll hand it straight over to her to go into some of the nuances of the report. So over to you, Anna.
Thank you so much, Charlie. And thanks so much to Adam for actually opening this conversation as well as you did. I think that really gave a great introduction and summarized it perfectly. So yeah, my name is Anna Krane. I'm the research manager at Tech Against Terrorism, and I'm absolutely delighted to publish this report. It's actually been almost to the date 2 years in the making. I found out today. And I'm also delighted to do that with today's speakers, because actually when I looked at my email inbox today, I saw that Anna, we had a conversation exactly 2 years ago. So it's wonderful to kind of see where we started and where we are now. And the interviews, which I'll elaborate on in a second, with David, Jason and Anna, as well as Gavin Sullivan, have been really paramount in doing that. Also, before I move on, I would say a massive shout out to the entire Tech Against Terrorism team, because you will see in this report that we've analysed many jurisdictions, and that was only possible because at one point I think the team spoke about amongst ourselves 12 languages, which made this whole research possible. So everyone from the Tech Against Terrorism team has been involved in some way or another. So I just really want to thank everyone for doing that. So in terms of the report, so Adam really sketched out as to why we thought it was important to analyse, which really was at first to kind of go into our internal policies. So when we designed the report, there were 5 research questions that were incredibly important for us to answer. So first of all, what terrorist designation systems are employed, as there are many different ones, we found out. Second of all, what implications does the designation of a terrorist entity have for the online content produced by or in support of that entity? Thirdly, is there content that falls outside of the scope of designation? And a big disclaimer for this report is to say there is definitely material, and when I say material, I mean terrorist content, that is not produced by a designated terrorist entity. And therefore, designation alone won't solve everything. But this report kind of examines where it can help. Fourth, what human rights safeguards exist in the designation systems deployed? Evidently, and also mentioned by Adam already, human rights lawyers, civil society, and experts have rightly so identified some human rights concerns with designation. And for us to be able to recommend designation as a tool to help moderate terrorist content online, that was obviously incredibly important for us to analyze and be able to address. Finally, and that really is the crux, how can global designation processes be improved to provide guidance on implications for online content, and as a result, improve online counterterrorism efforts? So in order to answer these questions, we've looked at 12 different jurisdictions, which you can see on the right. So 2 institutions, United Nations, European Union, and 10 different countries. As you can see here, this is just the start. It's our first report on designation, so we'll probably do a follow-up study on more countries. So in terms of the methods, so phase 1 was really to read everything we could about designation and to do the interviews. And the interviews were with the 3 speakers today, as well as Gavin Sullivan, a human rights lawyer. So from that, we then went to our country and institution deep dives. So this is where we read, obviously, the designation lists, legislation, government statements, interim codes, basically anything that we could read on these designation profiles. But what we also did is that we asked the governments for feedback on their profiles to make sure that we were accurate in our findings. And I just really want to also thank the respective governments and institutions for taking the time to actually go through our profiles and give us that feedback. We've had feedback from 8 countries and both the United Nations as well as the European Union, which has really helped to make this report more accurate. Finally, we've also done interviews with some of the governments, which were incredibly helpful, and again, looked at those human rights concerns as well. So then on to our findings. So this is a table on page 8 of the report, which kind of summarizes and compares designation systems in these jurisdictions. Now, obviously important to say is that in the report, we'll have way more detail on each and every individual system. But we wanted to see how does one compare to another? And when we say, okay, we follow these lists, then do the legal implications, are those actually the same? And what do we mean with that? So that is why we've also compared them in our report. And the main trends that we've observed, we think provides a gap online currently. There's also gaps offline that can be found in the report, but in this presentation, I'll focus on the online gaps. So first of all, the really thing to say is that there's a difference in designation systems. So there's different names. There's banning, prescription, political prescription, designation, dissolvement. And these things do not only have different names, they also are reliant on different legislation and therefore have different consequences. And this is quite difficult for tech companies to understand because they might be following up on a group that is banned, which doesn't mean necessarily that should be applied globally. That might be applied just in one jurisdiction. And especially smaller platforms, and when I say smaller platforms, I mean micro platforms, one person might have to analyze, well, as we did, 12 different jurisdictions. And it took us a while, and someone who is maybe not as specialized in this type of research, it might take even longer. Second of all, and really one of the main cruxes of this report is the legality of terrorist content produced by a designated terrorist group differs. So in some countries and jurisdictions, we found that yes, terrorist content is per se illegal under a particular definition. In other countries, we found that, for example, it had to meet the criteria of abhorrently violent or objectionable. And this again kind of complicates that. So again, looking then at the tech company perspective, it leaves the responsibility of adjudicating on particular types of content and say, okay, well, this meets the threshold of abhorrently violent, for instance. And that again kind of puts a lot of pressure onto these tech companies. Incitement to violence was also something we've examined. And interestingly, what we saw there is that overwhelmingly incitement to violence is illegal offline, but it's not always considered to be illegal online. And again, that changes per system. And this is important to consider because actually in the terms of service of many tech platforms, it is almost always illegal. So tech companies are almost going beyond what governments are doing. And that is something that we recommend against. We think governments should set the norms and they should take that responsibility, and tech companies shouldn't have to do that on their own. One of the overwhelming conclusions, which I think has been established by now, is that there is a lack of designation of far-right terrorist groups and entities. Germany is leading on this at the moment, and I'm sure that Anna will go into this more, but they are banned as anti-constitutional and not terrorist, which is a difference. And Canada and the UK are currently leading on this. Finally, we also looked at the review processes and appeal processes to kind of look at those human rights standards. And we saw that review processes very much differ in length, and there's often no protocol when a group gets disbanded or renamed. So we saw lists that, for example, had group names that are no longer actually the name of the group. And if you're a small tech company and you're using the names of the group to actually, to have a keyword and to moderate your platform that way, you might actually not be looking at the right group anymore. Another risk to this is obviously with a designation comes stringent human rights consequences for people and entities that are designated, so therefore they need to be accurate. Appeal processes, again, the transparency is sometimes hard, and it might be very hard to find out how to actually appeal to a designation status. So when we finished kind of those findings, we then went into what are the human rights concerns with designation processes. And I'll highlight a couple of these because there's more to read in the report. But what I mentioned is the lack of review processes and kind of the difference in that and the lack of transparency. What we also found is what has been highlighted massively, so I want to do that as well, is the potential disruption to humanitarian aid. This has been proven with the case of Hezbollah, for instance, and that designation status has blocked humanitarian aid from coming through. So it's very important to obviously be aware of that and be able to think about this critically. And judicial access and the right to remedy, that is exactly that, how hard it can be to appeal a designation status. So from all of this, we then thought, right, how are we going to, first of all, improve designation by countries and institutions before we can implement it as a mechanism to moderate terrorist content online? So there's a few key recommendations that I'll point out, which is, first of all, governments should make their list of designated, prescribed, or any other system, they're basically their list of whatever mechanism they use. They should make that very clearly accessible or easily accessible and transparent. I think without Anna, we wouldn't have found the German list. So it can actually be very difficult to find these, which obviously doesn't help with actually implementing then the consequences of those listings. Second of all, we recommend countries to separate basically a listing process from terrorism than any other status. So, for example, that there's not something like political prescription or anti-constitutional, but that is separated from terrorism. And this is because the consequences of a listing are very stringent, and we should only reserve that to terrorism in that sense. Enforce a three-layered system. I will actually come to this at the end of my remarks, so I'll skip this one for now. Very importantly, reflect the emerging threat landscape by designating more far-right terrorist entities. We completely understand that the far-right is sometimes less group-centric. However, there are far-right terrorist groups and entities that are still not designated, and they can be designated. So we recommend governments to do so. Establish regular review periods so that designated groups can, basically it can be reviewed, and they can be delisted or redesignated under a new name if that is the case. Lay out clear and accessible appeal mechanisms so that if inclusion is no longer warranted, that they can be removed. And then finally, importantly, and I think probably our report has kind of shown that this really helps if we include civil society, counterterrorism specialists, and human rights lawyers in the process of designating and delisting entities. So then, and I'll wrap it up after this, but what we then did is to say, right, we have all of these recommendations for countries. How are they supposed to then implement that? Do their actual designation models, do they work to implement that? And then we made some novel suggestions for, of our own, basically. And in the report, you can read how we do that. We come up with a framework for an international system as well as a domestic system. And when doing so, we compare ourselves to these criteria to make sure that actually, okay, does this suggested model, does it follow the rule of law? Does it provide clarity for tech companies, etc.? So in terms of international designation solutions, we've basically offered two possible solutions. One is a resolution and one is a recommendation. And what we recommend is that, either or a recommendation or a resolution, but that stipulates that official content produced by or in support of a designated terrorist groups, and that can be based on the domestic lists or the international lists, should be illegal when it leads to a domestic terrorist offense. That would provide clarity to tech companies. It would create some sort of international consensus whilst also protecting a domestic sort of agency over their own lists. So this is further highlighted in the report. And then again, we assess ourselves to those criteria. On a domestic level, we think, and I'm also delighted that we're going to hear from David later about the classification office, because we think that a three-layered approach will work. So we say first, we need to have terrorism legislation, whether that is the Terrorism Act or the TCO recently introduced in Europe, that says that material produced by designated terrorist entities that leads to a terrorist offense is illegal. So it is rooted in the rule of law. Then we say, have an online regulator which guides tech companies on how to implement that law, because that's actually very difficult to do. So something like Ofcom, for instance, in the UK. And then thirdly, we say the classification office, every country could have a classification office, or could consider to have one that bans particular pieces of content, because this really provides the ultimate clarity for tech companies by banning specific pieces of content. And designation can kind of be guided in that through every step as well. So I'll end here. Thank you very much. And I'll hand it back over to Charlie.
Thank you, Anna. That was an excellent overview of the entire report, which is amazing to summarize about 70 pages in 10 minutes. So I'm blown away by that. I will now hand over to Jason Lazakis, who is the professor at Middlebury and the previous director of the Counterterrorism Finance and Designations Office at the Bureau of Counterterrorism in the US Department of State. And he's going to give us a bit more insight into the US designation system and some of the challenges that are faced in actually implementing designation. So over to you, Jason.
Great. Thank you for the opportunity to join you all today. A fantastic report. Anna and her team crafted at Tech Against Terrorism. I highly recommend that you all read it after this webinar. 70 pages of really rich content. So I've been asked to speak a little bit about the work I did in my old position at the U.S. Department of State in the Office of Counterterrorism Finance and Designations. I see at least one person in the audience from that office. So great to see that. That's essentially 1/8 of probably the entire team that's charged with terrorist designations at the State Department. A really big chore that also gets to some of the challenges, I think, in some ways that I'm going to speak to later about the U.S. system. So just taking a step back, I think it's really important from the perspective of you all as viewers and listeners to understand why the United States has been perhaps quite easily the most significant player in the use of sanctions, targeted financial sanctions against terrorist actors. And then that story really does begin with 9/11, but taking a step back before 9/11, I think it's important to understand that prior to 9/11, the United States Department of State, since 1997, has been designating foreign terrorist organizations pursuant to the Immigration and Nationality Act. And even prior to 1997, there is this obscure executive order. It no longer exists at this point that provided the US government the capability to designate organizations that were involved in terrorist activity that was anathema to the so-called Middle East peace process. Now, that executive order was primarily focusing on groups like the Palestinian Liberation Front, groups along those lines. It wasn't global in nature. Then 9/11 happens, and essentially the Pandora's box of sanctions then opens. Of course, the FTO list had existed in 1997, but you had a mere 30 organizations on that list. Following September 11th, President Bush signed Executive Order 13224 in October of 2001. And it was at that time the U.S. Department of State and the U.S. Department of Treasury were provided shared legal authorities to designate both organizations and individuals globally as what they call specially designated global terrorists. So that is one of the primary mechanisms that the U.S. government uses and deploys to counter terrorist access to finance. The process of designating a terrorist is very cumbersome in the U.S. It has legal review checks built in, both when speaking to Treasury Department designations or State Department designations. So just to reiterate, State Department designates organizations pursuant to the Immigration and Nationality Act as FTOs, foreign terrorist organizations. State and Treasury share legal competency to designate organizations and individuals pursuant to EO 13224. And while I worked at the State Department, I do know that the Treasury Department process is equally laborious, with multiple lawyers reviewing what we call the administrative records or the evidentiaries, the underlying basis for the designation. So essentially you have legal checks from the Department of Justice, the Treasury Department, and state legal involved in that process. That process is extremely long. In my experience, in some cases, it could take more than a year for the US government to designate a terrorist actor, whether pursuant to the FTO legal authorities or EO 13224 legal authorities. And that really makes me pivot to the challenges related to the system the United States has in place to designate terrorist groups. And when I speak to this issue, I'm speaking both to the challenges related to State Department and Treasury Department. In some cases, I'll be very specific about challenges that may be specific to the State Department. The first is, and I think Anna made a very good point on this, is the composition of the US list. In 1997, you had 30 FTOs, and here I'm speaking again to the State Department now specifically. Now you have a number of FTOs on that list that are greater than 60 organizations. But not one of those organizations were what you call, or what the United States calls, a racially or ethnically motivated violent extremist group, or REMV is the US euphemism for essentially saying radical far-right violent organization. Not one. Now, in defense of the State Department, they did designate in April 6th of 2020 a far-right group known as the Russian Imperial Movement, pursuant to Executive Order 13224. And since then, both the State Department and Treasury Department have sanctioned a number of individuals within the Russian Imperial Movement. But relative to other Five Eye partners, when I say Five Eye, essentially United States, Canada, United Kingdom, Australia, and New Zealand, the US is very much behind the Five Eye partners for the designation of far-right actors, which is one of the chief recommendations from this report I hope you all read. But that also speaks to some of the legal challenges that relate to the designations of terrorists pursuant to US law. It's very difficult, for instance, to nearly impossible for the State Department to designate REMV actors, many of whom operate within the United States, because the law is very specific in the kinds of groups the US Department of State can designate. The legal criteria is very specific on this point, that the US Department of State can only designate foreign organizations. So you have this legal challenge that is difficult for the State Department to navigate. That's not to say or to excuse them from the possibility of exploring other far-right groups that exist and operate outside the scope of the United States. But this speaks to another challenge. And that challenge is the US system is very reliant on the use of sensitive information or classified information that goes into the administrative record that allows for the Secretary of State or the Secretary of the Treasury to designate terrorist actors pursuant to their legal authorities. Now, relatively speaking, the far-right threat is not new, but in terms of scope and the level of activity, it has increased significantly. You juxtapose that with the fact that the United States Department of State and other governments were very much focused on al-Qaeda in the wake of 9/11, and then on ISIS actors and the use of sanctions against both ISIS and al-Qaeda. You have a situation that has evolved where intelligence collection perhaps is lagging. And that affects the various policy bureaus like the State Department and the Treasury Department that have to create the underlying administrative records for designations. So I think one of these challenges is the increase of intelligence collection for the State Department and Treasury Department to be able to use their legal authorities more effectively. I will say also, it's important to understand that the underlying law that allows for the State Department to designate groups was created in 1996 by Congress and then implemented by the Department of State in 1997 and then modified in 2004 and hasn't been updated for nearly 20 years. And the 2004 update was essentially to move the legal review of FTOs, because there is a mandatory review of FTOs by the State Department. It used to be every 2-year basis, and that was moved to an every 5-year basis when the law was amended in 2004. So there is a mandatory legal review for the State Department, but it didn't really speak to the challenges related to designations that the State Department faces today. And that chiefly, as it relates to the radical right or REM-V actors, is the disparate nature of these actors. In many cases, academics will call them movements as opposed to groups. And it's very hard for the State Department, for instance, or Treasury Department for that matter, to designate movements. So this is another challenge that the law, if we were to take a look at it again, if the US Congress reviewed it, might be beneficial in terms of amending. The last thing I will say, and this also speaks to a point Anna made, is that the naming conventions of groups are very difficult for the State Department and Treasury Department to keep up with. When a group changes their names, and a great example of this is a group like Lashkar-e-Taiba, who've changed their names multiple times or created cutouts like Jamaat al-Dawa or Falah al-Saniyat Foundation to essentially circumvent sanctions, it does require another administrative record that needs to be crafted by the State Department or Treasury Department to actually designate that entity under a new name. And that can take quite a bit of time. So those are some of the challenges, just scratching the surface, and looking forward to the Q&A.
That was brilliant. Thank you, Jason. That was incredibly informative and really went into a lot of the challenges that, I mean, it's brilliant to make these recommendations, but actually putting it into practice can be incredibly difficult. So it's brilliant to have your insight on that. So I'll now hand over to Dr. Anna Meyer, who is the Assistant Professor at the University of Nottingham, to go over the German designation system and some of the challenges that is faced in the EU context. So over to you.
Thank you so much, Charlie, and thank you all for having me today. It's so great to see, I mean, I'm a nerd, but it's wonderful to see more work on designation and people taking interest in this, because it is important, I think, for reasons that have been quite clear in this webinar so far. I want to build on a concern that Jason raised that actually translates quite well into the German case, which is this lack of far-right terrorist designations. And I want to talk about the German case because that is a case where that's not actually true. The German case has a number of particularities when it comes to designation that both reiterate some of the problems that Anna and others have mentioned, while also raising some new questions, I think, around the effectiveness of far-right designation. So, since the end of World War II, West Germany, now unified Germany, has had the ability to designate organizations as anti-constitutional. So this isn't a terrorist designation per se, it's called anti-constitutional designation. And so a group can be banned for violating the constitutional order. For example, advocating overthrow of the German state, advocating for a return of Nazism, committing attacks against marginalized communities, because that goes against the principle of peaceful coexistence. So there are a number of ways that groups can be banned as anti-constitutional. So again, this isn't explicitly a terrorist designation mechanism, but it's used against many of the same groups that are considered terrorist in other jurisdictions. For example, it's under this banning mechanism that groups such as the Islamic State are outlawed in Germany. Likewise, two of the few white supremacist groups that have been designated terrorist by other countries, Blood and Honor and Combat 18, are banned as anti-constitutional in Germany. Being banned means membership in an organization is criminalized, assets can be frozen or seized. So in other words, very similar sanctions to those applied to terrorists in other jurisdictions. So while the parallels aren't perfect, I think the German case is really worth considering within this discussion of designation. One key reason why it's often not considered is the lack of transparency around bans, which is something that Anna hinted at earlier. When I first became interested in the designation procedure in Germany, I had to piece together records of bans from news articles and random government websites, all of which I should point out were in German and German only. Nowadays, there are more comprehensive resources available, including from the Center for the Analysis of the Radical Right, which has done some really incredible work on this issue. However, these resources too are riddled with errors, especially on the older bans and in the case of aliases. I'm currently working with a research assistant who's helping me piece through all of this. But let this be a first lesson to take away from the German case. Designation lists are useless if they are not publicly available, easily accessible, and translated into multiple languages for international tech companies to use. So that's a practical lesson. The second lesson that I'd take away from the German case is substantive, and it's a little bit harder to swallow because it's about the efficacy of designation as a mechanism against the far right. So since 1951, Germany has banned about 87 far-right groups as anti-constitutional. I say about because, again, we're still working through some of the early bans of groups with very, very similar names. But the bottom line is this is significantly more than any other country. As the report notes, the next highest number of far-right bans is in Canada, which is 9. So 9 versus 80 some, quite a gulf there. Germany is clearly an exceptional case with historical precedent, a lot of historical precedent for using these mechanisms, at least offline. Offline, the prognosis for designation is not good. One might expect a country with such extensive far-right bans over the past 70 years to have comparatively low levels of far-right activity, at least if designation were effective. I could throw statistics at you as to how that is not the case. I think the most convincing statistics are that last year, the Federal Office for the Protection of the Constitution reported 945 acts of right-wing extremist violence in Germany, which is a lot. We all heard also probably about in November, German police staging their largest raid in history against a far-right coup attempt. This is at least the third coup attempt in the last 6 years of which I am aware. And online coordination and communication has been central to all of these plots. So these are not stats that come out of a country that has its far-right problem under control. Now, it's hard to assess the degree to which bans have or have not had a direct effect on the overall level of far-right activity online or off. There could be even more activity in the absence of bans, or patterns of activity could be completely unrelated to patterns of banning. But I do want to caution against viewing designation as any kind of panacea. Tech Against Terrorism is very right to note that this is one tool among many in the counterterrorism arsenal. I would also note that it can be laughably ineffective at times. There are multiple recent cases of groups in Germany who were banned, reconstituted under different names or in slightly different forms, and remained politically active, including some whose members have run for political office whilst technically banned. We must be realistic, I think, about what designation can and can't do. I'd wager I'm one of the more pessimistic voices in the room on this, but that's because I've spent so much time examining 7 decades of Germany trying to use designation and mostly failing. So that's the second lesson, be realistic about expectations. The final lesson from Germany gets to the question of rights, which, as the report notes, is a very important issue surrounding designation in all jurisdictions. There's considerable justified concern that I think the report makes very clear about the use of designation in authoritarian environments to criminalize opposition and protest. But we also need to talk about this happening in democracies. So in Germany, the banning procedure arose, and the genealogy here is very clear, from the desire to protect what is known as militant democracy, which is a philosophical idea in Germany that the belief that the survival of democracy is so important that anti-democratic practices could be permitted if they would help maintain it. So there's a recognition that, in the German context, banning is a fundamentally undemocratic exercise. Now, you can think what you want about that, and there's many reasons to disagree. But the willingness of a democratic country to utilize designation so extensively, when this is the rationale behind it, I think should give us a little bit of pause. For what it's worth, to counter my own point, designation has largely not been used against domestic political actors who oppose the German regime using peaceful means. The German government has used other mechanisms to crack down on protest, but that's a different story. We do know that designation has allowed the expansion of police operations on and offline in Germany. And whenever police become more powerful, communities of color tend to face the brunt of that power. My point is that any discussion about expanding designation powers, regardless of jurisdiction, regime type, needs to consider seriously not only the positive effects of giving tech platforms guidance, which is important, but also the negative effects on vulnerable communities. And so I think their protection needs to be at the core of any discussion of reform. But I will stop there for now, and I look forward to questions and further discussion.
think, Charlie, you're on mute.
I am on mute. It always happens. There's always one. Thank you, Anna. That was a really insightful explanation of some of the downsides of designation and why this is such a kind of tricky sphere to navigate. I'll now hand over to David Shanks, who is the previous chief censor at the New Zealand Classification Office, to go over what a classification office does and how it works kind of in tandem with designation as a process and some of the successes and maybe challenges you've seen in New Zealand. Over to you, David.
Kia ora, thanks, Charlie. Thanks, Anna. Thanks, Tech Against Terrorism, for pulling this event together, providing the opportunity for this discussion, and preparing such a valuable and significant report. And wow, what interesting commentary and discussion so far, right? The strapline for this presentation is the need for clarity and transparency to moderate terrorist content. And if you listen to the discussion so far, we don't have that, do we? You know, we are fundamentally struggling in this area, and I understand deeply from my role previously some of the challenges inherent in this issue, but it's so important that we make progress on them. And I think this report is a significant step towards transparency and understanding. So look, just in terms of context about who I am and where I'm coming from in this discussion, I was the former chief censor in New Zealand. And yes, I know how absolutely dystopian that title sounds in the current context and in most modern contexts. But again, it's a legacy of just what some of the comments have been pointing to so far, right? We're talking about agencies, principles, legislation, modes of behavior that are premised on early 90s thinking often, or even earlier. We're talking about pre-internet structures and processes that we're now looking at to rely on to address fundamentally changing and evolving challenges in this space. And we are struggling, but progress is being made, and progress must be being made, because I think the challenges are only going to increase in this area. So look, Chief Censor, what does that actually involve, and what does that mean? Well, actually, I was effectively the leader of an office called the Classification Office, which had a mandate of reviewing and classifying material. Now, I think the Classification Office concept that's outlined in the report is focused quite closely on terrorist content, as you might imagine, given the genesis of the paper. But the Classification Office I led was very much a generalist organisation. In fact, we covered commercial content and age ratings classifications for cinema release films and other material, as well as evaluating potentially illegal content. And we weren't experts, so this is an office of 25 people covering the span of, harmful material, commercial, leading into the most extreme illegal material. And we weren't specialists in terrorist material at all, certainly not when I started back in 2017. Much of the material that was referred to us by law enforcement agencies was child sexual abuse material. That was where the majority of law enforcement effort, understandably was dedicated. And when I started as chief censor, I was aware of various publications that had been deemed objectionable under our law. And these were by and large ISIL, Al-Qaeda publications and material that, yes, were from designated terrorist organizations, but that did not matter so much in our process and our evaluation. What mattered to us was evaluating how harmful these publications could be. And when I reviewed our decisions on these publications, you could see that they would set out an ideology that provided a mandate or an excuse or an impetus to kill or cause atrocities. There was targeted groups that followers would be directed towards to kill or attack. And often there were means of carrying out the attack or means of committing violence detailed. So you had the cause, you had the targets, and you had the means of carrying out attack, all captured in a document or a publication. Very persuasive, very dangerous, very obviously directly contrary to any rule of law principle. Now, also as Chief Censor, though, through 2017 and 2018, we started to see referrals from law enforcement agencies that were abhorrent violent scenes, sometimes killings, graphic and dreadful material, but not easily identifiable or connectable to a terrorist organization. And at that point, we knew we were dealing with very deep and difficult waters in terms of determining the harm and illegality of that material. And we took a very conservative approach. And that took us to the horrific events of March 15, 2019, when a white supremacist terrorist attacker killed 51 people in 2 mosques in Christchurch, New Zealand, murdering innocent people at their place of prayer. A dreadful and horrific attack made more grievous by the fact that the attacker live streamed that attack, and that live stream went viral, as many viewers will recall. Now, the issue there is that that's not tech against terrorism in a way. That was tech for terrorism. That was weaponization of the internet, and that the attacker clearly had planned out these events to unfold in precisely the way that they did, to spread his message, his terrorist message and message of hatred as far and wide as possible. And there are many things that fall out of that I think are relevant to this conversation, because as you can imagine, leading the Classification Office of New Zealand, I was put in a situation where I needed to respond very, very quickly to an imminent real-time crisis as this terrorist publication went viral. But of course, this wasn't a designated terrorist organization. And from my perspective, that didn't matter. I didn't need to have regard to the fact that whether this was a terrorist organization or not. I could see the branding on the weapons. I could read the manifesto that set out the ideology. I could track through the characteristics of this product in terms of the video and the manifesto as identifying an ideology, branding it, identifying targets for followers to carry out attacks, and identifying the means by which followers can carry out attacks. So it was a terrorist publication that matched all the elements of harm that we would look for in previous type terrorist publications. So it didn't matter that the attacker at that point was not a designated terrorist. We mapped through our process and went, well, this is a terrorist promotional publication. And I think that's important in this context, because I think it's absolutely right that Tech Against Terrorism is saying we need to do better and we need to coordinate in terms of our designation processes, and we need to drag it into the 21st century. But we also need to look at what good looks like in terms of the outcomes and outputs and responses to events and shocks like this. Because even though I think the internet is in better shape to resist the exploitation of that vulnerability in terms of the viral propagation of live streaming of a terrorist event, I think the internet by and large is in a better place now thanks to the Christchurch call, GIF-CT protocols, but it's far from perfect, as the Buffalo live streaming event from last year in New York State highlights. The other thing is we still don't know how viral and how wide that those publications went, both in the situation in March 15 Christchurch or in the Buffalo event. We know they went viral. We know there was very large volumes of material prevented to be uploaded. We never know. And I've asked large tech platforms directly, well, you've provided advice of 1.5 million blocks of uploads of this content. Can you tell me how many people viewed this content? Oh, well, that's very difficult. So, we've got counterfactuals in terms of takedowns. We don't know how far this spreads, but we do know that we have followers who are inspired by events like March 15 in Christchurch and call out to it specifically. And in fact, there's been this dreadful kind of game of tag with white supremacist attackers in Poway, El Paso, Buffalo, all calling out to each other. They've never met. They've never spoken to each other. As far as we know, they haven't messaged each other. And yet, if you read their material, they feel that they're part of a group and a community. Is that a designated terrorist organization? Well, not according to our traditional analysis, but I think our traditional analysis is coming under pressure about what is a terrorist organization and how we think about that. Because I think we're seeing these virtual groupings form up, and I think we're going to see more of that in terms of incel culture and other areas of thought where people won't meet, but they'll have an association. So look, I could go on, but I want to make sure that we've got plenty of time for some questions and feedback. It's a fascinating topic. It's a vitally important topic. And again, I thank Tech Against Terrorism for doing this work to do the important job of bringing us into the 21st century. Thank you.
Thank you, David. That was a fantastic presentation and really insightful to hear some of your experiences, especially in dealing with the attack in Christchurch. It was very moving to hear kind of how you dealt with that. So let's move on to the Q&A. We've already got a stream of really brilliant questions coming in already. But to our audience, please feel free to continue posting any of your questions. We will try to get through as many of them as we can. But let's kick us off. I think this first question is perhaps best directed to Anna. So for countries that don't have their own designation systems, what's the best course of action to help provide more clarity on the issue? Should it be to push towards improved designation within the multilateral systems, so the UN and the EU, or perhaps to improve regulation on online content within their own jurisdictions? So yeah, Anna, if you'd like to go first, and then if anyone else has any insights afterwards.
It's a great question, and I think thank you so much for speaking, Anna, Jason, and David. That was really insightful, and really enjoying kind of bouncing off each other. But in terms of the question, obviously, I think this topic is so complex that it attracts real experts to join us today. So it's a difficult question as well, and I'll try and answer it to the best of my ability. So I think David has really pointed out that that designation doesn't cover everything, right? And in terms of the Christchurch material, that we need to have something else. And I think the classification office is a great example of that. But I think, as the question suggests, online regulation can also really play a vital part here. And for example, in the recent regulation introduced in the European Union, they define terrorist content, which is another way to then go about it. I would say, though, however, that our report really shows that we think that online regulation and designation, they shouldn't be as separate as they are now. They should be used in conjunction. And therefore, by saying that material produced by designated terrorist entities, when it leads to a terrorist offense, so for example, when it recruits someone to a terrorist organization, that should be made illegal. So therefore, I think for countries that don't have a domestic list, I would say, yes, look to the UN list and look to the EU list. But then you get the issue that there's no far-right organizations designated by either. So I think in terms of the local context of a country, and I think Anna really showed that with Germany as well, there is merit in terms of also then, coming up with your own list. On the other hand, I think this report has really shown that there are quite a few human rights issues with potentially designing such a list. But I think from this report and from the work that everyone on this call has been doing, maybe we can create guidelines or to kind of for countries that don't have a list to create a list in a human rights compliant manner. And potentially you could also consider creating a list for basically designated terrorist entities that is only applicable to the online realm, for instance. So I think there's a number of things that could be considered, but I think to separate online regulation from designation is less effective, and then you'll never have that specificity that tech companies will need. And I think, again, the classification office, by banning particular pieces of content, really provides that. So I think that, that mixture between regulation, designation, a regulator that helps to say to tech companies, right, well, what we mean is when ISIS is designated as a terrorist entity, that means that official content produced is illegal. And then a regulator could say, okay, what do we mean by this? We mean these particular media outlets, for instance, that promote or disseminate terrorist content on behalf of ISIS. And then we have a classification office that says, well, actually, we're going to make the newsletter that ISIS has illegal specifically. So I think that really that model, we think, grounds it in the rule of law and provides that specificity.
Brilliant answer. Does anyone else have any thoughts on that topic? If not, we can totally move on. No? Okay, let's move on. So I think this question, perhaps Jason, this might be in your wheelhouse. To what extent do you think tech companies rely on Western or Northern countries' terrorist lists, especially focusing on the UK and the US, possibly overlooking threats to other countries, for example, India, even though tech companies' products are used globally?
So it's a great question, and I look at it from two perspectives. My former perspective as the office director that was charged with sending recommendations up to the Secretary of State about which groups should be sanctioned and why, and then often thinking, why am I still seeing content associated with that designated actor online, associated with a major social media platform, particularly in the 2014-15 time period. There was a lot of ISIS content over major social media platforms. I know that's 9 years ago, but that was an existing frustration I had while sitting in the government position. But now that I'm also out of government, I'm a director of our Center on Terrorism, Extremism, and Counterterrorism at the Middlebury Institute, and a number of clients that we work with who are social media companies and understand the difficulties they have from where they sit in terms of dealing with these content challenges. I will say, I think there is a reliance to an extent among social media companies to look at so-called Western lists. In some cases, I think this points to the fact that, given the first question, that there are often lists that are domestic oriented that are, for the most part, created by Western states, as opposed to other states that may have more limited capacity to create their own designations lists or have limited legal authorities to do so. They are often adopting the UN list, and that's it. And I think this is part of that challenge. The second point I will say is, I think because of that, social media companies thus have to rely on something, and they do rely on those Western lists. And I will say the best example I of recent memory is the designation of the Russian imperial movement. You know, that was April 6th when that designation happened by the Department of State. And then April 7th, I would look at Russian imperial movement's channel on a specific social media platform or its page on another social media platform, and they were both removed. So there is a response with social media companies when they're aware of a designation and they're aware of these pages on their platforms for those kinds of content removals. But I will say some social media companies, for instance, have gone far beyond what the US list is, as an example, or the UK list, or any of the lists that are highlighted in the Tech Against Terrorism report. And I will say one example of that is Facebook or Meta. They have a pretty significant list. It's leaked a couple of times. About a year ago, it leaked, and there are a number of organizations on that list, and their dangerous org team is essentially implementing content moderation measures against those entities. And it's far more broad in orientation. It includes a number of so-called far-right groups that aren't on any of the Five Eyes or other countries that may have domestic authorities lists. So in that sense, while there is a focus on Western lists, some tech companies have gone far beyond what these terrorist designation lists look like.
Yeah, that's a brilliant answer. And I think it really does boil down, like you say, to how the tech companies respond, and especially due to their size. So like Meta, it's probably a lot easier for them to come up with their own list, but for a lot of the smaller platforms, especially some of the ones that we deal with, it's just not quite feasible for teams of 1 or 2 people. Okay, let's bounce over to the next question. I think, Anna, this one might be a good one for you. So the question is, why do you think the EU hasn't designated any far-right terrorist groups? I suppose despite Germany having banned so many as unconstitutional, why has the European Union as a whole not designated any far-right groups? And is it an oversight, or does the system kind of not function for banning that type of group? Any insights on that?
Got a few thoughts. There are a number of overlapping reasons here. Oversight is not one of them. So there are a couple of things happening. One is that the EU designation system originally was based on Security Council Resolution 1373, which is the resolution that was passed after 9/11, calling for countries to ban various terrorist groups. While the resolution itself is written very broadly, it was broadly understood to mean Al-Qaeda and a number of its affiliates. This has continued into the fight against the Islamic State. And so most of the infrastructure that the EU is drawing on is focused on Al-Qaeda and the Islamic State. So that historical precedent is part of the story here. Another part of the story is that part of how you come to be defined by the EU as a terrorist actor is by being charged with terrorism in an EU member state. And there's a lot of variation as to how that happens. It's not as frequent as you might assume, and for similar reasons, historically has not been used very frequently against far-right actors. So there's an omission of that as well. A bigger issue, I think, underlying all of this is a combination of mainstreaming of the far right throughout Europe. And so you have far right parties in the European Union who are not going to be very pleased to designate far right actors, but also just persistent racism over time and the unwillingness to see actions by majority white people as terrorist actions, which is perhaps a different way of wording the oversight issue and putting a finer pin on it of willing or at least socialized oversight of white supremacist and far-right actors as belonging in this terrorist camp in the first place. So you're battling against both historical legal precedent, but also socialization here.
That's a great answer, thank you. So David, I think I'm going to fill this one over to you. I guess this is more of an operational question on how classification officers work, but it's more to do with how many people do you really need to run a classification office? What sort of personnel do government, or do you think government should be dedicating to the system? And also, kind of as a separate part of this question, how did you prioritize what needed to be labeled as objectionable? I guess that's an entire discussion we could have for a whole webinar itself. But any high-level thoughts you've got on that?
Okay, thank you. So how many people do you need? Well, that's a really interesting question. I mean, I think, Jason, you mentioned you had someone joining us who represented 1/8 of the team that was dedicated to this area. I think I mentioned the office that I ran had around about 25 people, not all of whom were classification officers, covering a very, very broad span of content. How many do you need? Well, I think we could have definitely used potentially some more people, but I would say that even with a relatively small office, we could make a very big impact, particularly leveraging our research mandate and capability, and thinking carefully about how we actually publicized and made transparent our decisions and drew attention to them and used them as a basis for public discourse and engagement. So the more we did that, the more we could have an effect beyond, kind of, we could magnify our reach and effect and promote the conversations and awareness that needed to happen. So I don't think there's a right answer to how many do you need, but I can say that for New Zealand, we had an office of 25 and we could make quite a significant impact with that quite limited resource over a very broad span of content. How do we prioritize? Well, that's a really interesting question, because typically in terms of objectionable, unlawful content, we weren't picking and choosing what content we would classify. We would have it referred to us by law enforcement agencies, or our Department of Internal Affairs, which was the enforcement regulator for the Classification Act. But as Chief Censor, I did have a right of call-in power. So I could identify content myself and call it in to classify, and that was something I couldn't do often with a small group that had quite a full workload already. But I did apply that in terms of, again, maximum impact and effect. And one example of a publication I did call in was the Oslo Manifesto, the Breivik Manifesto, 1,500 pages or more than 10 years old. But why did I call that in? Because it had all the characteristics of an ideology promoting followers to kill, identifying targets, and being very, very detailed about kind of methods and tactics to achieve that aim. And I knew that that was a very significant reference point and appeared to be a very significant influence for the Christchurch terrorists. So that was something that I felt was necessary to engage with, and we were able to engage with community groups, religious groups, young people, and have actually a democratic, open discussion around that and document our process, which again, help move the conversation along. Thank you.
That's brilliant, thank you. Yeah, it's really interesting to hear about the kind of inner workings of how you run a classification office. I know it's not a thing that many countries have, so it's amazing to kind of get to hear the ins and outs of it. So I think we have time for just one more question, and then we'll do a round of final remarks. So I'll direct this one to Anna first, and then anyone else. I'm sure you'll all have some thoughts on this one, so please do jump in. Given the original intent of designation lists, what are the gaps in using designation lists when it comes to designating terrorist content online specifically? So how do we bridge that gap between offline and online?
I think that's a great question. I'm very glad it's asked, because what this report obviously intends to do is to say that designation can help with some pieces of material, those pieces being basically material produced by designated terrorist entities. But there's obviously content, and I would say especially on the far right terrorist and extremist side, that isn't really produced by one designated terrorist group. And I think on the far right, we can see more diffuse networks, more, for example, accelerationism as an ideology, and content that could be classified as hybrid threats. So it overlaps with a lot of other online harms. So you're basically looking at material that isn't really produced by a designated terrorist organization or a organization to begin with. It's more a diffuse network. And I think David commented on this when we said, well, the Buffalo Manifesto, for instance, and the Bratislava attack and that person's manifesto, they highlight a lot of the work from these other lone actor far right terrorist attackers. And there's different ways to go about this. I think what is interesting is that New Zealand, for instance, has also designated Brenton Tarrant as an entity. What I also find very interesting is that Canada has designated James Mason. So that then kind of says, okay, what are the implications for siege material then? So that kind of goes to show that, terrorist content, it's not always produced by groups. And designation as such, therefore, has its limits. I do think more can be done, and in the report we do comment on this, but as always, there's room for a follow-up report to say, how do we actually deal with the designation of these lone actors? Because on the other hand, I would say that, for example, in the US, some of these, what I would classify as far-right terrorist attackers who've committed terrorist attacks, do not get prosecuted for terrorist offenses. And I do think that that is not how it should be. I think if you commit terrorist atrocities, you should be labeled as a terrorist, or at least be found guilty of terrorist offenses. So I think designation could kind of stretch there as well. But yeah, just to wrap up before I open it to the others, I think what we've seen is that designation as it stands has advantages and disadvantages. In our report, we kind of say, well, this is what countries could do to make them, to improve them, basically. And then that can apply to particular pieces of terrorist content. But I think the first question that we got today about online regulation is also paramount in this. It has to go with incitement to violence, with online regulation, with a classification office, and with other existing legal mechanisms that we can use to counter this issue. Because what we also say at Tech Against Terrorism is to say we have a lot of legal tools already in our arsenal, and to come up with new and new and new, and like every time new legal tools, yeah, that borders on, well, we don't think that's necessary. We've got the tools. We just have to use them and improve them so that they become fit for purpose. So I'll stop there, and I'm very curious to hear the answers by the other speakers.
Brilliant. Yeah, does anyone else have any final thoughts on that or on the topic as a whole?
I might just add a couple of points on that. Where are the gaps? Well, I think we're highlighting that there are a lot of gaps. There's useful thinking and progress to be made. I would suggest that if I look across the landscape, we've identified an area that needs significant kind of work and modernization, if you like, in terms of designation. At the same time, there's really fundamental shifts happening across the world in terms of online regulation and harms regulation generally, which is kind of nestled up against this conversation. And I know Tech Against Terrorism has been thinking about this, but you know, it's a very significant kind of coordination effort to look at what's happening around the world in terms of thinking about putting in place new online regulators, how that connects with this area. But it's vitally important. Someone needs to be taking in that big picture and drawing those connections. And I would say one of the fundamental gaps is we're talking about terrorism as a thing that's just a given. We also need to, which is true, but we need to be thinking about what are the pathways to terrorism? What's the kind of funnel, or the rabbit hole that is leading potentially greater numbers of people into terrorist ideologies. And that takes you into a whole other area of mis and disinformation, conspiracy theories, and algorithmic amplification, which is aside to, but also intimately connected with some of the outcomes and issues that we're dealing with here. So there's importance in progressing each individual kind of leg of the supporting structure here, but really important task here to think about the integrated picture, given that it's changing so rapidly. Thank you.
Brilliant, thank you. Jason, would you like to do a closing remark, and then over to Anna to round us off?
Sounds great. And not so much a closing remark, but rather a response to a couple questions that were in the queue that I thought were quite good. Tim and Gavin asked a question that really I think I can weave an answer in that answers both their questions. Tim had asked, for instance, you know, that process of designating within the United States seems very long, can be a year, you know, what goes into that. I'm not going to tell you everything that goes into it because, you know, I would need many more than a couple minutes to do that. It ranges essentially from the identification of an individual or entity through either open source information and analysis at the front in the beginning stage to the actual publication of the Federal Register notice, which affects the designation, and the publication on OFAC's website, the Specially Designated National List. And in between, the most cumbersome part of that process is the legal review process, the so-called clearance process we call in the United States, where we have multiple sets of lawyers, again, review these packages. And this answers Gavin's question now, because in the US system, executive order designations can end up in court at the district level, federal district level. And then the FTO designations actually can be challenged immediately at the Court of Appeals, one court higher than the district level. And quite often we have seen at least one case I can recall ended up in the Supreme Court. So US system does allow for judiciary review. And I just want to comment where I think there's this question on the EU. EU has used the list very sporadically. You had 20 groups on the list, approximately 13 individuals pursuant to the EU listing regime. And I would just say, I think there's a great amount of deference paid to the US executive branch when it comes to designations that may not exist within the EU. And those that follow sanctions cases know very well a lot of that may stem from the Yassin al-Qadi case, where the European General Court and the European Court of Justice essentially rolled back that designation of the EU. And I think that part of that legal review process has made the Europeans perhaps a little skittish on how they use the terrorism designation tools that they have available to them. You couple that with the fact that they have a 6-month review process, as opposed to like the US system for the FTOs is every 5 years. That's a pretty laborious process to do every 6 months. And I think that's part of the challenge for the EU as well.
Great, thank you. And Anna, final comments?
Sure. I want to conclude with a thought on this question's come up several times of what is a group, and especially how do far-right actors challenge that. Somebody used the term lone actor earlier, and that term makes me bristle every time. And the reason that it does is because whilst there are certainly different organizational structures in a number of these far-right groups that are not like as concentrated in cells, perhaps as we might be used to seeing with some Islamist groups, so there's not a clear hierarchy all the time. There certainly are, as has also been noted, considerable communication, whether active or passive, between far-right actors in various locales, drawing on the same ideas. Every single time that one of these far-right mass shootings, terrorist attacks takes place, we find additional evidence of Brenton Tarrant, for example, traveling to Europe and talking to identitarians in Austria, or some other kinds of exchange that are happening that way. Even though he wasn't formally a member of that group, he was certainly involved with its ideologies. So I think there's an opportunity here, and I don't have an answer to this, but for us to think about what constitutes a group for purposes of designation, which should also lead us to think about the ways in which we may have overemphasized or been willing to create or impute group structures on other actors that research has continually shown are perhaps not as organized, formally at least, as we might have been led to believe. So as always, there are motivation questions here under where are we willing to see structure? Why are we willing to see it there? And there are larger political questions as to what actors we feel belong in this space in the first place.
That was an excellent way to round us off. So thank you to all of our speakers. I have just dropped in the chat for everyone to see is a link to the final report. It's now live on the Tech Against Terrorism website, so please do go spend some time, give it a read, share it among your networks, friends, family, if they're interested. Thank you again to all of our speakers, to everyone that's contributed to the report in any way, big or small. It really has been a group effort. And also an incredible thanks to Anna for leading on this project, which really has resulted in what is sure to be a landmark report. But thank you all. Finally, enjoy the rest of your days and enjoy the report. Good night.